Hello, everybody. Welcome. You've sued your doctor, and now your case is on for trial. And now your attorney asks your doctor a question, and all of a sudden your doctor answers, and you get so outraged, you get so upset. All of a sudden you jump up out of your seat, and you're a goddamn liar. You son of a bitch, I know you're lying. Do you think that's going to help your trial by jumping up and making that outburst? You want to know what this is about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now here's the scenario. You brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your particular injury. And now you claim that your injury is significant and permanent. And now, when you bring your lawsuit, the doctor whom you sued, the doctor that you trusted, turns around and says, "What are you talking about? I didn't cause your injury. I didn't do anything wrong." So that's his first defense. He says, "I did nothing wrong." Second, he says, "You know what? If I did something wrong, well, guess what, Mrs. Patient? So did you." That's the second defense. The third defense to arise is, he says, "Listen, if I did something wrong and you also did something wrong, whatever I did really didn't cause or contribute to your injuries." That's the third defense. Not four, three. That's the third one. And then here's what else comes up. He turns around and says, "Listen, I didn't do anything wrong, but if I did something wrong and you also did something wrong, well, guess what? Maybe what I did caused your injury, but your injury really is not as bad as you claim it to be." So now, those are four typical defenses that we see in almost every single medical malpractice case here in New York, where a patient who believes they suffered injury now has brought a lawsuit against their doctor or hospital staff. So now, the defense refuses to negotiate. They claim they did absolutely nothing wrong. So what does that mean for you? It means that your case will ultimately go to trial 2 to 3 years later. The discovery part of your case will take 2 to 3 years to actually get to trial. So now, let's assume you've gone through that entire process. And now, it's time for trial. Well, your attorney calls as his very first witness the doctor whom you have sued. Now, you might be asking, how can you do that? Well, the easiest way is to take a subpoena and serve it on the doctor you sued. But more importantly, let's focus on the trial itself. So now, the doctor has gone ahead and has come into court. Why? Because now he's required to be in court to testify. Now, you might be asking yourself, how is it that the attorney, your attorney, can now begin to cross-examine your doctor if he calls him as his own witness? Isn't he vouching for his credibility? The technical answer is no, he's not technically vouching for his credibility because he is technically a hostile witness. He is the defendant in the case. You, as the injured person, are known as the plaintiff, bringing the lawsuit. The person whom you have sued is known as the defendant. So now, in this civil lawsuit, where you are trying to obtain money as a form of compensation for all the harms and losses and injuries that you've received because of this doctor's carelessness, now you're in the middle of trial. This is the very first witness. Your doctor is up on the stand, and your attorney is now cross-examining your doctor. So now, in the course of cross-examining, your attorney asks a question, and the doctor replies. And you know in your heart of hearts, no, not on this side, you know in your heart of hearts that what the doctor is saying is 100% incorrect, that he's lying through his teeth, that he's lying out of both sides of his mouth. And now you get so upset, you jump up out of your seat, you're a liar, you're a goddamn liar, you son of a bitch. Now, that outburst, the judge gets furious. He says, "Sit down, I don't want to hear you. I will not have that in my courtroom." And now you have no choice but to sit down. But still, you're seething with anger. And now, a few minutes later, your attorney is questioning the doctor, and now he's asking him more questions. And the doctor gives a very plausible answer. And you are so outraged. In your mind, you know that the doctor is lying through his teeth. And you can't control yourself. You jump up out of your seat. You say, "You liar! You are a goddamn liar! How could you do that? The jury knows it. I know it. The judge knows it." And now the judge is furious. The judge is telling you, "Sit down. Sit down. One more outburst, I'm going to throw you out of court. And you won't be allowed back in." And the judge tells your lawyer to keep you in check and make sure this doesn't happen again. So now what do? You've got to sit down. But here's the better question that I asked at the very beginning of this video. The question is, does this help your case? Does this outburst, these multiple outbursts, letting the jury know that you know that the doctor is lying, does that help your case? And the answer is no, it doesn't. And let me tell you why. But first, I want to take a water break. Okay, so now that we have the microphone checked, all right, hopefully we have audio. Didn't have audio this morning. But now let's get back to the question. So why doesn't this help your case? I'll tell you why. It's because the jury is at a significant disadvantage. They don't know what you know yet. They only know a little piece of information. And let me tell you what they know at this point. They only know the information that the attorneys have given to them during the course of jury selection, which is not very much. And then once they have been selected as jurors, now at the beginning of the trial, the judge gives the jury preliminary instructions. And that gives them a basic outline of what they can expect during the course of trial, what will happen during the course of trial. So now, your attorney is told to call his first witness. And now he calls Dr. Jones to the witness stand. They don't know anything about Dr. Jones yet. Now, after a few minutes of Doctor being on the witness stand, all of a sudden you jump up out of your seat and have this crazy outburst. From the jury's point of view, they don't understand what just happened. They don't know what you know. Your attorney hasn't yet shown inconsistencies in this doctor's testimony. So they don't fully understand what it was and why you're so upset. And now when it happens a second time, again, they have very limited information because your attorney is now trying to get information from your doctor while he's cross-examining him. And now, again, the jury doesn't have an idea. They're at a disadvantage because they don't know exactly what you know. They haven't seen any evidence. They haven't reviewed any documents. They haven't heard your testimony. They haven't heard from medical experts yet. So they are at a huge disadvantage. And for you to now go ahead and make a whole ruckus and to make a whole big stink claiming that the doctor's a liar, well, guess what? The jury's going to think you're somewhat crazy. The jury is going to, let me rephrase that. Your credibility is going to be affected because the jury doesn't have all the information that they need to reach a conclusion yet. So you will find that the best trial lawyers in New York have a number of different strategies to show that a witness or a doctor or whoever's on the witness stand is lying. Oftentimes, a really good attorney is not going to turn around and call out a doctor or a witness and say, hey, you're a liar. Aren't you lying now? Were you lying then or were you lying now? They're not going to make it so obvious. Instead, they're going to do things a bit more subtle. And here's a great strategy that's used often with this type of witness. So now you should know that during the course of the lawsuit process known as discovery, there is a point in time where we will have an opportunity to question the doctor whom you have sued. And we do that in a question and answer session in his lawyer's office. This is legally known as a deposition or an examination before trial. Let me grab a little sip of water. All right, so what happens next? So this deposition, this question and answer session takes place in his attorney's office. And it's an opportunity for us to learn information about what the doctor did and why he did it. And now there's no judge there, there's no jury there, and there's only a court reporter there with the attorneys. And now we ask questions the doctor has to answer. And his answers form the basis of his pretrial testimony. And now that information gets recorded and transcribed and put into a booklet called the transcript. But you should know that that testimony, those answers, carry the same exact weight as if the doctor is testifying at the time of trial. So now, if the doctor has said something that's inconsistent between what he said a year earlier during his question and answer session and what he's answered at the time of trial during cross-examination, now we can highlight to the jury the inconsistency. We can show them that the doctor may not be as truthful as he claims to be. But now you might think, okay, once you catch the doctor in a lie, once you find this inconsistency, why don't you hammer it home over and over and over again? Doctor, look at this lie. You lied then and you lie now. And you lied then, and which one is a lie? Which one is the truth? Yeah, you can find some attorneys to do that, but you will find that the best attorneys are ones who make their point, show the inconsistency, drop it, and then move on. You want to know why? Because at some point, the doctor's going to try and come up with an excuse as to why he gave an answer one way earlier and now has a different answer And that excuse may be entirely plausible. And if it's plausible, the jury may give the doctor greater credibility and not understand why your attorney is trying to beat him up on the witness stand. So it can backfire on an attorney if he continues to hammer the point over and over and over again. That's why the best attorneys drop it and move on. So now you're thinking, okay, why do they do that? I'll tell you why. Because they wait until the witness is off the witness stand so he can't answer anymore. And we do that during closing arguments. During closing arguments, that's the time for us, the attorney who's bringing the lawsuit, to go ahead and highlight to the jury that key point where the doctor showed that there were inconsistent statements, that he was inconsistent, or in other words, that he was lying, that he said something that was not truthful, untruthful. And there are lots of different ways to phrase it. But the bottom line is, you can now show it to the jury, you show them in writing the inconsistencies, you explain to them and highlight that if a doctor cannot be believed because he's inconsistent about one little thing, well then how do you know he can be consistent and truthful about the rest of those things he said? And that's a very powerful tool. And that's just one little strategy that we can use to show and highlight to the jury that a witness is being inconsistent or not entirely truthful, and without having the litigant or anybody in the back of the courtroom jumping up out of their seats and yelling out, "You son of a bitch, you goddamn liar, I can't believe you're doing that." That's a really important difference. And so the best thing to do is to let the lawyer do his job. He knows the strategies, he knows what works, and that's why you hired him, because he has experience doing this. So to answer the question I raised in the beginning of this video, will it help your case if you try and let the jury know immediately that the doctor is lying or being less than truthful? The answer is no, you won't. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what happens in these civil lawsuits involving accident matters, medical malpractice matters, and even wrongful death matters here in New York. You know, I realize you're watching this video because it's coming up in your Facebook feed, right? As you're scrolling through. Well, if you found it and now you're stopping and watching this, I hope you found some great information that will help you understand how these types of cases work. And if you're watching this on the replay and now are actively searching for this information but need more answers because you still have questions to your matter that happened here in New York, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516, hang on, let me put this up here so you can see it. It would be 516, where are we? Here we are. 516-487-8207. Put that up on the thing. There we go. So you can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's OGINSKI-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. I hope you have a fantastic day. Bye-bye, everybody.